I'm Ben Meiselas from the MeidasTouch Network. I want to take a deeper dive into the Department of Justice's opposition to Donald Trump's application with the Supreme Court to vacate or essentially overrule portions of the 11th Circuit's order granting the motion for partial stay filed by the Department of Justice. In other words, the 11th Circuit returned the 100 classified records to the Department of Justice that the Department of Justice obtained during the August 8th search warrant that was executed at Mar-A-Lago. And what Trump is asking the Supreme Court to do is allow the special master to get those documents, again, those 100 classified records, so that they can then be disseminated to Trump because Trump wants to look at those classified records. So that's what's going on there. We've done a deep dive analysis into the overall motion that the Department of Justice has filed through its Solicitor General. Take a watch of that video. We've also done another analysis into a very brilliant jurisdictional argument that the Department of Justice made, where they basically said, look, Donald Trump cannot invoke the Presidential Records Act because he didn't follow the process. He didn't give the records to the National Archives. He stole the records, and so you can't invoke the PRA when you steal records and you don't go through the process. But to the extent he's claiming that this is a Presidential Records Act issue, which it's not, because he stole classified records and stole tens of thousands of other government records as well. But to the extent it is a PRA issue, the only place that has jurisdiction for PRA issues is the District of Columbia District Court, not Trump's selected judge in the Southern District of Florida. We did a whole breakdown on that, but I want to focus on an area in the Department of Justice's motion, which may go a little less noticed, but to the keen eye, I think you can see that this has a lot of potential import here. And this relates, by the way, to prior reporting that we did here on the MeidasTouch Network that Christina Bobb, who claims she's not Trump's attorney, but was his custodian of records in connection with the Mar-A-Lago search-related matters, that she has been speaking with DOJ investigators and met with them last Friday in Washington, D.C., to discuss that she actually didn't conduct a diligent search, which is what she certified in a declaration, but that she was told by another Trump lawyer, Corcoran, that the search had been done, that it's all good, don't worry about it. She did hedge on her declarations and did say, based upon what was told to me in her declaration to the Department of Justice, but she said a diligent search was made, and clearly a diligent search wasn't made because the Department of Justice, when they went in on August 8th, found 100 classified records pretty quickly and found multiple other folders, like 40 folders that have classified markings with documents that were removed. And there's a portion in the factual discussion of what's transpired. The Department of Justice wrote to the Supreme Court in their opposition to Trump's application before the Supreme Court, where they talk about this incident. I want to read it, and I want to reflect on a line, though, that I think is very important and where I think this investigation is also going, which no one is really talking about, but I think is very, very, very important. And this is what it says. It says, in response to a grand jury subpoena from May, applicant, Trump's lawyer, and his custodian of records produced an envelope, this is on June 3rd, containing approximately 36 documents bearing classification markings. Applicant, Trump, did not assert any claim of privilege and did not suggest that any of those documents had been declassified. To the contrary, the envelope had been wrapped in tape in a manner, quote, consistent with an effort to handle the documents as if they were still classified. Some of the documents in the envelope bore classification markings at the highest levels, including additional compartmentalization. Remember, this is referring to grand jury subpoena is issued to Trump in May after they cherry-picked documents to give back in January. NARA and the Department of Justice know they're lying. A grand jury in Washington, D.C. issues a subpoena. You have the custodian of records, Christina Bobb, comes out with this red weld to give it to the top counterintelligence official from the Department of Justice who shows up, and they give this folder over that has those records that I just described. Applicant's counsel, Trump's lawyer, represented that those records had been retrieved from a storage room at Mar-A-Lago where boxes removed from the White House had been placed, and that no responsive records were located anywhere else at Mar-A-Lago. So there's no other records any other location. Applicant's custodian, Christina Bobb, applicant's custodian provided a sworn certification in writing, quote, on behalf of the office of Donald J. Trump, end quote, that a, quote, diligent search was conducted of the boxes that were moved from the White House to Florida, end quote, and that, quote, any and all responsive documents accompany this certification, end quote. The certification further stated that, quote, no copy, written notation, or reproduction of any kind was retained as to any responsive document. Then this factual section in the Department of Justice's filing goes on to talk about how the FBI then uncovered evidence that this response to the grand jury subpoena was not complete and was false, and then they finally had to execute the search warrant at Mar-A-Lago on August 8th. But the part I want you to focus on, which not many people are talking about at all, was this end piece. The certification, the last sentence, the certification further stated that, quote, no copy, written notation, or reproduction of any kind was retained as to any responsive document, because where a lot of this conversation has been about mutilation, concealment, obstruction, hiding it, the documents in the office, the documents in the storage room. Even with the documents, though, that were cherry-picked to be returned in January and then later on June 3rd, which they then submitted a false declaration to the Department of Justice saying there was nothing else. When the Department of Justice executed the search warrant on August 8th, they found 11,000 other government records, approximately 200,000 pages of documents contained within the documents themselves, and those 100 slightly more than 100 classified records. So it was a false declaration. But here's the great point. Did Donald Trump make copies, written notations, or reproductions regarding the other documents that were cherry-picked and turned over? And are those at other locations? Now, the line that I just read is an interesting line because it really doesn't have to do anything with the ultimate appeal at issue that is at least being addressed, the appellate jurisdiction that was being contested by Donald Trump to the Supreme Court. Donald Trump's essential argument to the Supreme Court when he's asking them to vacate what the 11th Circuit did in returning the classified records is said that the 11th Circuit was not empowered. They did not have appellate jurisdiction to say that the special master could not have those classified records and then disseminate those records to Donald Trump as part of the special master proceedings that Judge Eileen Cannon ordered. Trump argued the 11th Circuit can deal with injunctions, but the special master part of that order was not an injunction. And the 11th Circuit argued, and the Department of Justice argue in this motion, well, there's something called pendant jurisdiction. If the issues are inextricably intertwined, Judge Eileen Cannon's order of an injunction and special master are an intertwined concept. So, of course, the 11th Circuit can exercise appellate jurisdiction. The Department of Justice argues in its brief, and the 11th Circuit argued in any event, it is an injunction. Judge Eileen Cannon's order was an injunction that incorporated the dealing with the documents and not allowing the Department of Justice from looking at the documents. Injunction and the special master process were all part of an injunctive order. So the Court of Appeals can have appellate jurisdiction over injunctions on interlocutory basis or before there is a final judgment in a case. Or in any event, the 11th Circuit Courts of Appeals have jurisdiction over what's called a collateral order, an order that really forecloses any other relief that would require a Court of Appeals to interject, or else there will be whatever's happening will be completely done and you can't unring the bell. And so for here, if Donald Trump gets access to the classified records and the Department of Justice's investigation is compromised, that's a collateral order because the Department of Justice won't have the ability to unring that bell if the 11th Circuit doesn't intervene. And so clearly they have jurisdiction, and Donald Trump's argument is purely on the jurisdiction. He doesn't make an argument about harm to himself and irreparable injury he would be caused, which is one of the factors that he's supposed to be arguing to the Supreme Court. He didn't even make that argument, nor did he make the argument that one of the findings that the Supreme Court would have to make to grant the relief is that would the entire Supreme Court grant certiorari review or to hear this case and then rule favorably for Trump with a grant of certiorari. Trump doesn't even argue that either. So that's one of the things the Department of Justice points out. So the point I'm making, though, is those are the issues that the Department of Justice just had to address, right? They didn't have to put that line in there. And if they wanted to give a fulsome factual background on what took place, that line, that sentence there, though, did not have to be there. So they're sending a message there. It's a subtle message, but I think they're sending a message there to Christina Bobb, to Trump's lawyers, to other individuals, maybe Christopher Kise and others, saying, we know. It wasn't just hiding. It wasn't just obstructing. We believe you have records in other locations, but we also believe that part of the certification by Christina Bobb, quote, no copy, written notation, or reproduction of any kind was retained as to any responsive document. Note that too. A written notation. That's how classified these records are. You can't do a handwritten notes or take photographs on your cell phone or whatever of these documents. That's just as bad as keeping the documents. Even a handwritten note where you extract the information from the document is a violation. And so I think they're saying that happened. And I think we're going to learn about that in the coming days and weeks. So stay tuned to that portion, that factual portion, where I think we will learn more that Trump and others were making photocopies and reproducing and keeping other records of the records that they even returned, that they were caught having, in addition to the ones that the Department of Justice obtained during the August 8th search warrant. That's why I think that's in there. I'm Ben Meiselas from the MeidasTouch Network, giving you my legal analysis. Hit the subscribe button right now. We are on our way to 1 million subscribers. Hitting the subscribe button is free. Really, if you watch these videos like you do all the time and you don't hit the subscribe button, what are you doing? Just spend a minute, hit the subscribe button. Boop, 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 subscribe button. Super easy to hit it. Also, if you want to support our independent media channel, one way you can do that as well is because we're not funded by any outside investors. You know that, right? We're powered by democracy and fueled by you. So if you want to help grow this thing, and if you're wondering, what can I do to get involved? Wherever you are in the world, you can help right now. We need your help. Go to patreon.com/MeidasTouch, patreon.com/MeidasTouch. Head to patreon.com MeidasTouch. Now a number of exclusive benefits. You could become an honorary producer of the podcast. Your name will appear at the end of the MeidasTouch podcast. Other exclusive behind the scenes footage. You get postcards for me and my brothers based on certain exclusive packages on Patreon, as well as exclusive podcasts. So what are you waiting for? Head to Patreon, patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.